jurisprudence lecture on or talk, a small talk on Hans Kelsen's pure theory of law. So, without taking much time, let us get started with Hans Kelsen's pure theory of law. So, let us have a reflection on few basic facts related to Hans Kelsen's pure theory of law. So, he was basically an Austrian jurist, means he was a person who was very closely associated with John Austin's theory of analytical law. So, and he was also a very good, strong legal and political philosopher. Talking about his works, he has authored a book, okay, or he was the one person major involved in the Austrian constitution, framing of the Austrian constitution in 1922, okay, and to a larger extent still it is valid, it has been still followed and existence. Now, reflecting back to his times, due to rise of totalitarianism. Totalitarianism is a form of governance when they were a sort of governmental disturbances in Austria. He was forced, okay, he was left with no other option to live or to relocate himself to Germany. So the theory of pure theory of law of Hans Kelsen's is also referred in as Rennie researcher. Okay, so let us look at some of the basic facts of Hans Kelsen. So Hans Kelsen refers law as a normative science. Okay, so he calls it as a normative science. Now, what does means is law norms may be distinguished from science norms on the ground that norms of science or norms of is, which are based on cause and effect, such as law of gravitation. So here he quotes that as we have the scientific laws, okay, like for example you take gravitation law set forward by Newton, so it's a science law and it is based on the science principle that the gravity of earth pulls back an object and nothing can go against the earth's gravity. In the similar way, so Kelsen also states that law is also a normative science. Okay, so it is based on norms of is, okay, which are based on cause and effect. So if there is something happening, if there is a cause, then there should be an effect, there should be an implied result of that particular thing. Okay, so he based on this he calls it as a normative science. Then he talks about hierarchy of normative relations. Okay, and he says he does not want to include in his theory what the law ought to be. Okay, so he says like he doesn't want to speak about a thing that will define or that will say what law ought to be, and speaks of his theory of law as structural analysis, as exact as possible of the positive law, an analysis free of all ethical or political judgments of value. So he states hierarchy. Hierarchy means a specific order. and he says like his law theory is free from any sort of influences, and according to him, what law ought to be, it is to be. Okay, and it should be organized as a structural analysis, or it should be exact as possible of the positive law. Okay, and the analysis of such a law should be ethical and political judgments of value. It should not be influenced by any sort of external bodies. Then he further adds on separation of law from other social and moral sciences. So here Kelsen defines science as a system of knowledge of a totality of conscious cognitions, thinking patterns, okay, capability of thinking. So he refers it as knowledge of a totality of cognitions, systematically arranged according to logical principles. Okay, and Kelsen's Grundnorm is analogous to Austin's concept of sovereign, without which law cannot be obligatory and binding. Now, if we can recollect from Austin's theory, in Austin's theory, sovereign is highly empowered, and a command laid down by sovereign has to be adhered, has to be followed by all. But here, Kelsen states that the concept of sovereign, without which law cannot be obligatory and binding. Kelsen's pure theory of law is a theory of positive law based on normative order, eliminating all extra legal and non-legal elements from it. So here he adds more prominence to his principle, making it a little stronger when compared to Austin's theory of command. Then Kelsen lays more focus on ground norm. In Kelsen's pure theory of law is based on pyramidal structure of hierarchy of norms which derive their validity from the basic norm, which will be termed as Grundnorm. So in Kelsen's pure theory of law, so he formulates a basic norm, okay, a foundation norm. Okay, on the basis of this norm, all the other norms are formed. Means in a way, it forms a pyramid structure, pyramid of norms. Kelsen considers legal science as a pyramid norms with Grundnorm. At the apex, means at the top you have the Grundnorm. The subordinate norms are controlled by norms superior to them in hierarchical order. The Grundnorm is, however, independent of any other norm being at the apex. The process of one norm driving into power from the norm immediately superior to it until it reaches the Grundnorm has been termed by Kelsen as concentration of the legal system. The system of norms proceeds from downwards to upwards, and finally it closes at the Grundnorm at the top. So in a pyramid of norms, Grundnorm will be always at the apex. So all the norms will finally pave a way to the Grundnorm. Okay, so these are the 5 essential points main points related to Hans Kelsen's pure theory of law. Moving further, let us look at essential features of Kelsen's pure theory of law. So the first one is the aim of the theory of law, as of any science, is to reduce chaos and multiplicity of unity. So one, like sometimes the concepts may become either vague or too complex. Now here the main aim of Kelsen's theory was to make it more scientific and reduce the confusing aspects in the theory and bring down all the multiplicity, bring down all the concepts, trying to unify it as much as possible. Legal theory is science, not a violation. Okay, it is a knowledge of what law is, not of what law ought to be. So this is another very significant feature of Kelsen's pure theory. So it says legal theory is a science. Okay, it is nowhere other than any other sciences. Okay, and it, since it is based on the knowledge of what is and not what ought to be, means uh, is talking about a circumstance where a law is considered, so it should be considered as it is. There should not be any sort of further projection what it should be supposed to be. Okay, then further he says law is a normative, not a natural science. Okay, he says like as other sciences are based on uh, principles, same is the case with Helsen, Kelsen's pure theory of law. Legal theory, it is concerned with effectiveness of legal norms. Legal theory as a theory of norms is not concerned with effectiveness of the legal norms. So a theory of law is formal. Okay, a theory of law is formal. A theory of way of ordering, changing contents in a specific. So it should have a formal approach for things to be in the right place. Particular system of positive law is related to possible positive law. The relation here we have to state that the relation of legal theory to a particular system of positive law is that of possible to an actual law. Let us look at postulates, okay, or some things that are assumed or suggested by Hans Kelsen's pure theory of law. So first he make an assumption, or he suggests that law and state are not two different things. So if there is a law and the law should hold good for the entire state, so he doesn't differentiate between a law and the state. Okay, so in Kelsen's pure theory, he treats law and law of a state as the same as the state. So he draws no distinction between public and private law. So in the eyes of Hans Kelsen, pure theory of law, okay, there is no distinction between public and private law. There is no difference between natural and juristic persons. And he doesn't talk about, or he is not in favor of individual rights. Okay, and he also doesn't support the concept, or he doesn't give much weightage to the supremacy of international law. Okay, so just make a change. It's not an analytical theory of John Austin. Here we are discussing Kelsen's theory. So it is, sorry for the mistake. It is, please read it as a criticism of Kelsen's theory. So first criticism that Kelsen's theory received was related to Grundnorm. So Grundnorm was in a vague and confusing, because according to Kelsen, it is placed at the apex, okay, and all the beneath norms have to be fulfilled and finally pave way to the Grundnorm. So what exactly this Grundnorm was a little bit difficult to understand and at times confusing. That was the first criticism which Kelsen's theory received. Okay, and the second thing is he talked about purity of norm, which is highly impossible or very difficult to be maintained. It's very difficult to maintain the state of purity of a norm. And though he clearly lays down uh, in a very beautiful way all the essentials of uh, the pure theory, so many of the critics find it that it has got very less practical significance. And Kelsen's pure theory of law completely ignores natural law. He doesn't talk about natural law. He doesn't take into consideration the concepts of natural law. Now, somehow many of the critics hold a strong opinion that international law is the weakest part of the theory, which was not properly explained or justified. So that brings us to the end of a session where we had uh, good inputs on Hans Kelsen's theory, pure theory of law. Hope the session was good and it will be useful to all of you. Okay, please do like and share the good work. Please do join my channel sufivoice.com. Have a wonderful day. Thank you.